All right, Mr. Noe, are you ready to proceed with Mr. Laharaga?
I certainly am, Your Honor. Dustin, turn that laptop that way so the judge can see you.
Okay, this is file 24-52016-PH. Gregory and Annette Meyer versus Dustin Laharaga. We are here today for an arraignment on an alleged violation of personal protection order. We are proceeding today partially in person and partially by Zoom. Sir, you are Greg Meyer.
I am.
And ma'am, you are Annette Meyer.
I am.
And Mr. Noe, do you want to place your appearance on the record?
Yes, thank you, Your Honor. Charles Noe, appearing on behalf of and with the respondent, Dustin Laharaga.
And sir, you are Dustin Jean Laharaga.
Yes.
Mr. Laharaga, you're before the court today on an order to show cause. The show cause alleges that you violated a valid personal protection order by continuing to make verbal threats and make inappropriate gestures toward the Myers, among other things. The maximum possible penalty for violating a personal protection order is up to 93 days in jail or up to $500 in fines. Do you understand that?
Yes.
You are entitled to be represented by an attorney, and if you can't afford an attorney, the court would appoint one for you at public expense. Obviously, Mr. Noe has made his appearance on this already. Mr. Noe, do you know how Mr. Laharaga would like to proceed with respect to the alleged violation?
Your Honor, at this point, my client would stand mute and ask this meeting after the evidentiary hearing.
All right, I will enter a not guilty plea for Mr. Laharaga. We will set this for a evidentiary hearing. Ms. Clark, we'll need, I think, an hour for an evidentiary hearing in this case. Francis, are you there?
Oh, yes, I'm here, Judge.
Okay. Did you hear me? We need. Oh, sorry. Go ahead.
Oh, no, you're fine. August 13th at 2:30.
Mr. and Ms. Mice, do you have any issues with that date?
No, we do not.
Okay. Mr. Noe, are there any issues with that date?
Yeah, Judge, I'm in a jury trial on that day for Judge Shea.
August 26th at 9 a.m.
My only concern with that, Your Honor, is that the current active PPO expires on August 28th.
All right, so this wouldn't affect whether or not that is a violation, and you have an ability to request an extension by filing a motion.
Okay.
Judge, August 26th, I'm in a divorce trial all day with Judge Anzalone. starting at 9.
August 27th at 2:30.
That works.
Any issues with that date?
We do not.
Okay, so we'll set it for August 27th at 2:30 PM. The court will issue a scheduling order with those dates and other important dates for witness list exchange and exhibit exchange that will be in that order. So when you receive it, please read it carefully and make sure you comply with it.
That'll
Okay,
be
so that'll be
in person, right?
that is in person, correct?
Thought so.
All right, so that'll be all for this case today. We'll see you back on August 27th at 2:30 PM.
Thank you, Your Honor.
Thank you. Okay, Ms. Underwood, are you ready to proceed with Mr. Scivoletto?
Yes, Your Honor, thank you.
This is file 25-22237-FH, People versus Jonathan Paul Scivoletto. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Scivoletto this morning, Your Honor.
Yeah, and Ms. Underwood, you know where we stand with Mr. Scivoletto's case today.
Your Honor, Mr. Scivoletto is under an income withholding order. He is complying with that order. He continues to work and make payments. I've discussed with Ms. Brenner that he needs to step up the payments. He is working full-time, but it is not quite meeting enough for the arrearage. So Mr. Scivoletto is aware of that, Your Honor. And we would ask, and I believe the Attorney General's office would have no problem with the 60-day adjournment, Your Honor. I will do the order, Your Honor, with Ms. Brenner's permission.
That's correct, Your Honor. He is making payments, but we're not hitting even his current obligations. So the arrearages are continuing to climb. So he either needs to find additional employment, look into getting his order modified, but we need to make forward progress. So I'm okay with adjourning to give him a chance to do that. But, you know, he does need to figure something out.
And Mr. Scivoletto, you may, I'm sure you want to go to the front of the court and as soon as possible, schedule a review hearing.
Barry, I've done that. I'm waiting on the hearing to come back.
Okay, thank you.
All right, we'll set that then for September 24th at 8:15 AM.
Thank you, Your Honor.
Thank you, Your Honor.
September what, sir?
September 24th
Okay,
at 8:15. You'll log in using all the same Zoom information that you used today.
yes, sir. Thank you.
Okay, so you can go ahead and log out then. Okay, Ms. Underwood, do you need to speak to Mr. Moore, Anthony Moore?
Just very briefly, Your Honor.
So where's the 70 salsas they were supposed to do? I see the chips, but ain't no salsa.
Okay, Mr. Moore, you're gonna need to move to a different location where there aren't people talking in the background.
Yes.
And I'm gonna put you in a breakout session with Ms. Underwood if you'll give me just a moment. Good morning, Mr. Glazer. Mr. Russell is here in the courtroom. Do you need to speak with him?
Yes, I do.
Okay. Mr. Russell, the bailiff's going to set up, log in on an iPad that's right outside the door. If you will.
He's in the hallway.
Oh, he's in the hallway.
Yeah.
Okay, this is file 20-19796-FH and 20-19849-FH. People versus Anthony Harris Moore. We are here today for a hearing on an alleged probation violation, and we are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Moore this morning, Your Honor. At this time, I've spoken with Ms. Tolley and Mr. Moore. Mr. Moore had made $100 payment on Monday, Your Honor. He owes about another 300, I think. We would like, and I don't think Ms. Holly would object to a 2-month adjournment for him to get that completed, Your Honor.
That's correct, Judge.
Okay, thank you. Ms. Holly, let's go with September 24th at 8:15 a.m. then.
Thank you, Your Honor.
Thank you.
So, Mr. Moore, you'll log in on September 24th at 8:15 a.m. with all the same Zoom information that you used to log in today.
Okay. And that's even if my fine's paid completely?
Talk to your probation officer about that. If you
Okay.
get
If your
taken
fines
care
are
of.
paid, I'll probably submit a discharge and ask for it to be canceled.
Okay.
Okay. So you are all set. You can log out for today then. Joseph. Okay, let's see. Mr. Russell, can you hear me?
Yes, sir.
Okay, I'm going to place you in a breakout session with Mr. Glazer. If you give me just a moment.
Okay.
Good morning, Mr. Monterez. Do you have Mr. Merritt with you at your office?
I do not, Your Honor. In fact, I'm in my vehicle right now, but I did just receive an email from Mr. Merritt in which he said he does not have the Zoom ID. Would you mind providing it to me, you or your staff, so that I can get him on here?
One second.
Of course. Thank you so much.
I just sent that to you in the chat.
I received it, Your Honor. I'm going to shoot this over to him, and I'm going to give him a call to make sure he receives it and anticipate he'll be on in the next 5 minutes.
Okay, sounds good.
Thank you, sir.
Okay, Ms. Underwood, Mr. Hennigan is not here or logged into the Zoom session. Ms. McClenny Vidalez is not here or logged into the Zoom session.
Your Honor,
Mr. Rodriguez is not here or logged into the Zoom session.
Mr. Rodriguez. One moment, please. Your Honor, I tried to reach Mr. Hennigan. His number, I don't believe, worked. Ms. McCanny Vidalez, I have no knowledge as to where she is. I spoke with her recently.
Okay, let me call the Hennigan case then. This is file 25-22289-FH, People versus Dewan Naray Hennigan. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Rhonda Underwood for Mr. Hennigan, Your Honor.
And Ms. Underwood, we discussed it off the record, but you have any information about Mr. Hennigan? He is not logged into the Zoom session.
I have no knowledge as to his whereabouts. Ms. Brenner, I would ask, I believe he's making payments.
He posted his bond in May. He paid in June. He has not paid in July yet. So, Your Honor, I would ask for a bench warrant to be issued in 48 hours. Give Ms. Underwood the chance to try to reach out to him and get him to turn himself in.
Okay, Ms. Brenner, do you know the outstanding balance on his account?
Yes, Your Honor. It is $8,270.63.
Okay, I will allow Mr. Hennigan the 48-hour grace period. It does look like this is the first failure to appear. If he does not contact the court or Ms. Underwood within 48 hours, I will issue a bench warrant for his arrest. And I will set bond on that bench warrant in the amount of $8,270.63.
Thank you, Your Honor. We'll prepare that.
Okay, Ms. Underwood, do you need to speak to Mr. Ballard?
I don't believe so, Your Honor.
Okay, let me call Mr. Russell's case and then we'll do Mr. Ballard next. Mr. Russell, do you want to come forward to the podium, please? This is file. Oh, I'm sorry, we're having an issue with our recording. Okay. This is file 25-22184-FH, People versus El-Shabazz Donnell Russell. We are here today for a pretrial conference in this case, and we are proceeding today by video conference and in person. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.P. McClure, on behalf of the people.
John Glazier on behalf of Mr. Russell.
Okay, and sir, you are El-Shabazz Donnell Russell?
Yes, sir.
All right, Mr. Glazier, where do we stand with Mr. Russell's case today?
Your Honor, we want to set this for trial, I guess.
Okay, and how much time do you think, Ms. McClure, that we will need for a trial in this case?
Your Honor, probably just one day. And I just wanted to indicate for the record that the plea offer outstanding is plead to count 1 with the dismissal of the remaining charges, including the felony firearm, which is a mandatory 2 years in prison if convicted. And in addition, there's an agreement to no Michigan Department of Corrections sentence. So with that, I just wanted Mr. Russell to know what was going to be expiring when this gets set for trial.
Okay, Mr. Glazier, do you agree that one day would be sufficient?
It'd probably go 2 days, counting instructions and jury selection and all that. A day and a half anyway, I would guess, but.
All right, Ms. Clark, could we have a 2-day jury trial date, please?
Yes, sir. We could do Thursday, October 2nd at 9 a.m. and then Friday, October 3rd at 9 a.m.
Okay, Ms. McClure, does that work for the people?
Yes, that works for the people.
Mr. Glazier?
Yes, that's fine.
All right, let's do a final pretrial then on September 24th at 8:15. And the court will send out a scheduling order with those dates in it.
Okay. Mr. Russell, you should come in and see me like next week and bring your ex-girlfriend with you. Okay?
All right.
Okay.
All right, we are all set for today.
So October and September.
September 24th is your next pretrial. That's the next time you have to appear in court.
Okay.
Trial date is October 2nd.
Okay.
All right. Thank you, Your Honor.
And John, if he does want to take that plea, just let us know and we can get it scheduled.
All right.
This is file 24-21953-FH, 25-22224-FH, and 25-22307-FH. People versus Joseph Wallace Ballard. We are here for a probation violation pretrial on the 24 case, a final pretrial on the 25-22224-FH case, and a pretrial in 25 case. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
PB McClure, on behalf of the people.
Rhonda Anuda, on behalf of Mr. Ballard, Your Honor. I believe the court is in the possession of a signed plea agreement and advice of rights for Mr. Ballard that he wishes to accept this morning, and he will also be pleading guilty to the violation, Your Honor.
Okay, where did those documents get sent? Because I do not have those.
Oh, I believe they were sent to your office. Let me check. I believe your staff was going to get the advice of rights sent over to the jail, Your Honor, a couple days ago. And I believe we emailed the plea agreement.
Yes, Judge, we have received the advice of rights. The clerk's office does have those.
Okay, when did the plea agreement get sent? Because I don't have that.
Okay. Thank you,
Or
Your
if you
Honor.
have it, can you just, if you have it, can you just send it again?
I have one, I just don't have a signed one by defense, so
I have a signed one.
can you forward it to the judge?
I will try to do that. I'm sorry. I thought this was done. Okay. One moment.
Judge, did you finish your trial?
We did just yesterday.
You guys get a verdict, or you're still waiting for that?
No, the jury came back yesterday with a verdict that's guilty.
Okay, yeah, that was a long trial.
Okay. All right, so I do have the signed plea agreement. Ms. Underwood is now in the courtroom and just handed that to me. So Ms. Underwood, do you want to state the plea agreement for the record? Then I'll have Ms. McClure confirm this back. Ms. Underwood, do you want to state the plea agreement for the record? Do you need that?
Thank you.
Okay.
Mr. Ballard will be pleading guilty to the following. Count 2, fleeing and eluding third degree. Count 3, obstruction of justice. And added count 6, use of methamphetamine, a 1-year misdemeanor. The additional terms are people shall dismiss counts 4 and 5 and the habitual offender supplements in the instant file. In addition, the people shall dismiss all charges in file number 2522307FH. And I don't believe the prosecution has any objection to Mr. Ballard being released to rehab. I know I've discussed that with Mr. Sneed, if rehab can be set up for him.
All right, is that a complete and accurate statement of the plea agreement, Ms. McClure?
It is, and I'll just state for the record, there is no sentence agreement or COBS in this case.
Okay. Mr. Ballard, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Joseph Wallace Ballard?
Yes, Your Honor.
Mr. Ballard, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-22224-FH to count 2 third-degree fleeing and eluding a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 3, obstruction of justice?
Yes, Your Honor.
Do you understand the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine?
Yes, Your Honor.
And is it also your intention to plead guilty today to count 6, use of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes, Your Honor.
And let me ask also, is it your intention to plead guilty today in file 24-21953-FH to the probation violation?
Yes, Your Honor.
And in that case, do you understand that you had previously pled to carrying a concealed weapon and the maximum possible penalty for that offense up to 5 years in prison?
Yes, Your Honor.
And you had also pled guilty to assaulting, resisting, obstructing a police officer in that case, and the maximum possible penalty for that offense up to 2 years in prison.
Yes, Your Honor.
Is it also your intention to plead guilty today to the pending contempt you have in that case for failing to appear at the probation violation summons hearing?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
It is, Your Honor.
Ms. Underwood?
Yes, Your Honor.
Is that also your understanding, Mr. Ballard?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ballard, that if your pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
With respect to the probation violation, do you understand that you would have all of those same rights with the exception that it would be required that your guilt would have to be proven by a preponderance of evidence rather than beyond a reasonable doubt?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 27, 2025 in the city of Adrian, County of Lenawee, that you did commit the offense of third degree fleeing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about the same date in the same location that you did commit the offense of obstruction of justice?
Guilty.
And how do you wish to plead to the charge that on or about the same date and in the same location you did commit the offense of use of methamphetamine?
Guilty.
And how do you wish to plead to the charge that you violated the terms of your probation by failing to report on January 14, 2025 or thereafter?
Guilty.
And how do you wish to plead to the charge that you committed contempt of court by failing to appear for the probation violation hearing on March 5th, 2025?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter those pleas?
Yeah.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Ballard to plead guilty today?
None, Your Honor.
None, Your Honor. At this point, Your Honor, could I go back and get in front of my screen so that I can take Mr. Ballard through the events?
Okay, go ahead.
Thank you.
Mr. Ballard, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Underwood, would you like to establish the factual basis?
Thank you, Your Honor. Mr. Ballard, let me take you back to January 27, 2025. Were you in a vehicle in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
And in that vehicle, did you possess the substance methamphetamine? Or did you use the substance, or sometime during that date, did you use the substance methamphetamine?
Yes.
And you know that that is an illegal substance,
Yes.
and you had no prescription for it.
No.
And at that time, were you in the operator of a motor vehicle, and were you given a visible or audible signal by hand voice or siren by Deputy Esposito?
Yes.
And was he a police officer in performance of his duty?
Yes.
Was he an official marked car?
Yes.
And you knew it was a police officer?
Yes.
And he wanted you to stop?
Yes.
And you failed to stop, correct?
Yes, ma'am.
Okay. And the speed limit was 35 miles per hour or less, and you speeded up to pass that, correct?
Yes.
And when you were stopped, you continued to resist the police. Is that correct?
No. When I stopped, I got tased and I was
okay.
quiet.
Okay. You were obstructing justice you knew you had a warrant, correct?
Yes.
And that's why you were evading police,
Yes, ma'am.
correct?
Yes, ma'am.
Okay. I believe the facts are sufficient.
Ms. McClure, are the people satisfied?
The only question I have is, do you agree that Deputy Esposito pulling you over was lawful?
No, I don't think it was lawful. I turned 5 corners before he turned his sirens on. My tags and my plates were all legal. And after my 5th corner I turned, then he decided to flick his lights.
Did your license plate come back to your name?
No, I was in a company vehicle.
Okay. And did you make any violation of the motor vehicle code?
No.
Then I don't know if we can accept the plea. If he's contesting that the stop wasn't lawful.
Mr. Ballard. Could I have a brief breakout with Mr. Ballard?
Okay, Mr. Monterez, I do have Mr. Merritt here now. Are you ready to proceed with his case?
I am, Your Honor, and I appreciate the court's patience.
Okay. This is file 25-22173-FH, People versus Brian Merritt. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
PB McClure, map the people.
Your Honor, Nicholas Monterez on behalf of Mr. Brian Merritt, who's present via Zoom this morning.
All right, and Mr. Merritt, just going to send your request to unmute. And sir, you are Brian Merritt, correct?
That's correct.
Okay. Mr. Monterez, where do we stand with this case today?
Yes, Your Honor. At the last pretrial conference, I informed the court that I'd be sending over some deviation material for people's consideration. I understand that Mr. Sneed is out. Initially, I'd sent that information to him, and then upon following up with the prosecutor's office, was informed he'd be out, and it was going to be forwarded to Mr. Bayonetto, who I believe the individual I spoke with believed would be covering today. So that information has been sent out. I also did receive a written offer before sending that information from Mr. Sneed. So at this point, I'd be asking if the people have had an opportunity to review that, or if it's needed to wait for Mr. Sneed to review in order to potentially have a resolution in this case.
Okay, Ms. McClure, do you know where things stand in that regard?
That's probably something Mr. Sneed's gonna have to review. I've not received anything to review for this morning.
Your Honor, in that case, I would ask for a brief 1 to 2 week adjournment. I believe that Mr. Sneed's out of office email says that he'll be back on the 28th. So if that's
He'll be back on the 1st.
Oh, I apologize, on the 1st. So I would ask for some time for him to be able to review that. This doesn't seem like a case that's going to go to trial. I believe we'll have resolution. So I just need to give Mr. Sneed the time to look over the relevant information.
Okay, let's go with August 27th at 8:15 a.m. if that date works.
Works for defense, Your Honor.
Okay, so August 27th at 8:15 a.m. and you can log in using all the same Zoom information that you used to log in today.
Thank you, Your Honor. Mr. Merritt, I'm about to step into court physically. I'll give you a call when I get done there.
All righty. Thank you.
Thank you, Your Honor. Thank you, Ms. McClure.
Okay, we're back on the record in People versus Joseph Wallace Ballard. Ms. Underwood, where do we stand with Mr.
Your Honor,
Ballard?
I would like to continue taking the plea. I believe Mr. Ballard memory has been refreshed. Mr. Ballard, do you recall you did not stop at the stop sign at the corner of Michigan and Locust? Is that correct?
That's correct. I rode through it.
And the officer was behind you, correct? And stopped you, correct?
Correct. After I rolled through the
Thank
stop
you.
sign, he flicked the lights on. I remember now.
Thank you.
The people are satisfied with the factual basis, Your Honor.
All right, Mr. Ballard, with respect to the probation violation, you had previously been placed on probation in the 24-21953-FH case. Is that correct?
Yes, Your Honor.
And one of the conditions of your probation was that you report to your probation officer as directed. Is that correct?
Yes, Your Honor.
And did you fail to report on January 14, 2025?
Yeah, I reported when I first got out of jail, and then I thought I was supposed to report in February, and I didn't report in February. I had a couple deaths in the family, and my mind just spiraled. I got out of jail December 29th, and I reported the following week, and then I wasn't aware I was supposed to report on the January 14th. I had a mix-up because I had downstairs probation and upstairs probation. The downstairs told me to report in February, so I thought I had to go see Joanne in February.
All right. As a result of that failure to report on January 14th, the court sent out a summons for probation violation and set a hearing for March 5th, 2025, and you did not appear at that hearing. Is that correct?
That's correct. My aunt's funeral was that day.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has, Your Honor.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Ballard has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 5th at 8:15 a.m. Mr. Ballard, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
All right.
Your Honor?
Yes.
Could we have a release to rehab provision added to Mr. Ballard's bond if we can get that done, Your Honor?
Ms. McClure, do the people have any position on that?
I'm not sure. I'm not familiar enough with the case, other than, maybe Miss Holly can weigh in if she's kind of had him on probation, but I guess my inclination would be to wait for that PSI to be done.
Yes, please. I'm afraid if he goes somewhere, I might not be able to get him for the interview, so the PSI should be done first.
All right, so what I'll do is allow for a release to a residential inpatient treatment facility after Mr. Ballard's pre-sentence investigation has been completed.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor. Thank you, Joanne.
Miss Holly.
All right.
Mr. Holly. Sorry.
Mr. Ballard, you can let the officer with you know that you're done with court for today. And
Thank you.
Call for Cassie Coley and Andy Torres. Okay, Mr. Murphy, do you need to speak to Mr. West?
I think we're ready to proceed on the record unless you want to talk to me.
And Ms. Underwood, do you need to speak to Ms. Sanchez?
Briefly with Ms. Sanchez, Your Honor, and I believe Mr. Dotson is also here.
Oh, yeah,
I don't
okay.
believe I need to speak to him.
Okay. Let's do Mr. Dotson's case then, and then I'll have you speak to Ms. Sanchez.
I will be right down, Your Honor.
And Your Honor, I believe Rhonda said that Mr. Hennigan had logged on. We had previously done a bench warrant for him, but she said he was logging on. So
okay, I've got one here. Let me see if that's. All right, good morning, sir. Are you Mr. Hennigan?
Yes, sir. Can you hear me?
Yes, just 1 second.
Okay.
We're ready, Your Honor.
Okay, this is file 25-22289-FH. We're back on the record in People versus Dewan Hennigan. Mr. Hennigan has now logged into the Zoom session. So, Ms. Underwood, where do we stand with Mr. Hennigan's case?
Your Honor, Mr. Hennigan is making payments. He has not made July's payment yet.
That's coming Friday. It'll be
Okay,
here Friday. Yep, this Friday.
Okay,
great.
Mr. Hennigan, I'm just going to ask you not to interrupt, please.
I'm sorry.
And so in discussing it with Ms. Brenner, we've agreed, Your Honor, to a 60-day adjournment, allowing Mr. Hennigan to keep making payments. And I will do this tip to adjourn order, Your Honor, with Ms. Brenner's permission.
That's correct, Your Honor. So once we see that payment history, we'll be able to move forward with the delay of sentence plea. So I believe he's in good progress so far.
Okay, so I'll adjourn it then to September 24th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Hennigan, your next date is September 24th at 8:15. You'll log in using all the same Zoom information that you used today.
September 24th at 8:15.
Correct.
Thank you, sir. I will be there. I will use the same number, and I will see you September 24th at 8:15.
Okay, thank you.
Yep. Oh, what the fuck?
All right, Mr. Hennigan, we can still hear that, and that's clearly not appropriate.
My apologies, Your Honor.
Just say he's lucky he logged out. Mr. Dotson, you want to come forward? This is file 25-22227-FH People versus James Alfred Dotson. We are here today for a pretrial conference in this case. And we are proceeding today by video, partially by video conference and partially in person. First, let me ask the attorneys to place their appearance on record, beginning with Ms. McClure.
Phoebe McClure, may I have the people?
Sorry, I think Ms. Underwood was coming up to be here per person for that.
Thank you, Your Honor.
So again, this is
Ron Underwood,
file.
Mr. Dotson,
Yeah, okay.
this morning.
All right, and Ms. Underwood, where do we stand with Mr. Dodson's case?
I believe the court is in possession of a plea agreement and assigned advice of rights for Mr. Dotson, Your Honor.
Okay, you want to state your understanding of the plea agreement for the record, and I'll ask Ms. McClure to confirm. Do you want to state the agreement for the record?
Yeah, the agreement is Mr. Dotson will plead as charged with no supplements, Your Honor. And there is a no upfront jail provision, I believe.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
I don't see the no upfront jail on the plea form.
I apologize, Your Honor.
That's okay. The only other thing that's on the plea form is.
I was thinking of the file.
Can you guys hear me?
Yes, go ahead.
Okay. The only other thing on the plea form is that there would also be a dismissal of a district court file 242661 SM. But with that dismissal, the defendant would have to agree to pay $88.47 in restitution to Meyer.
All right, Ms. Underwood, is that a complete and accurate statement?
That is accurate, Your Honor.
Mr. Dotson, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are James Alfred Dotson?
Yes, I am. And may I speak?
Ms. Underwood, I
would like to withdraw my plea.
Talk to your attorney first,
Well,
because
I would like to change the counsel and withdraw my plea. I tried to talk to her.
okay, so you haven't pled yet, so there's no plea to withdraw.
Okay. Well, can I set the matter for trial? No, I would like to change the counsel. I had the hearing this or last week. I tried to talk to her. I went in and told her I want a trial, and I left with a signed plea and I definitely felt coerced and definitely felt bullied into it. And I would like to change the counsel. No.
All right, it's clear that Mr. Dotson does not want to enter a plea this morning. There's also apparently issues between Mr. Dotson and his attorney with respect to that plea agreement.
Are you scared? I'm just kidding.
Okay, Ms. Coley, I need you to be not talking right now.
I'm sorry, I can't hear you. The officer is trying to get out. Okay. I can hear you now.
Okay, I need you to not talk.
Okay.
So, Mr. Dotson, you have been assigned a public defender to represent you. There are limited circumstances in which I can remove a public defender. Because generally what I can do is assign the public defender's office, and the public defender's office assigns who they think should handle each case.
Okay.
If you'd like to have a hearing on whether or not the standard has been met for me to remove Ms. Underwood from the case, we can do that. I also know there's a process by which the public defender's office sometimes reviews the situation and will assign someone different through their own office. So I don't know how you would like to proceed with that.
Your Honor, I will talk to my boss, and we will see if Mr. Dotson will be assigned another public defender.
All right, so what I'll do is set this for August 27th at 8:15 a.m. And if there's a new public defender assigned at that time, we'll see where we stand at that time. If we need to proceed with the hearing, we can schedule it at that time.
Your Honor, can I provide my own counsel if I can
If
afford it before
you have the ability to hire your own counsel, you're always welcome to do that.
Okay, all right, thank you.
Right. All right, then we are all set, I think, for today.
August 27th?
August 27th at 8:15.
All right, thank you very much. Every day.
Okay, Ms. Underwood, do you need to speak to Ms.
I'm just going to
Sanchez?
talk to Ms. Sanchez for a second, Your Honor.
Okay, go ahead. Ask for me. Sir Glazier, do you need to speak to Mr. Torres?
Yes, I do, Your Honor.
Okay, and Mr. Murphy, do you need to speak to Ms. Coley?
Just briefly, Your Honor.
Okay, Ms. Sanchez, you want to come forward, please? Is file 25-22308-FH, 25-22309-FH, and 25-22310-FH. The 308 case is set for a pretrial. It also has 3 pending contempt of courts from when it was in district court. 309 file has the same thing, and 310 file is a pretrial. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
B.B. McClure on behalf of the people.
Ron Underwood on behalf of Mrs. Sanchez, Your Honor.
And where do we stand with Ms. Sanchez's cases today?
At this time, Your Honor, Mrs. Sanchez is going to accept the offer of the prosecution. Ms. Sanchez will plead guilty to count 1 in 2522309-FH as charged. There will be no upfront jail. All remaining counts will be dismissed. There will also be a restitution of $517.65 in file 25223-FH, and she will admit that for restitution purposes only. And I have signed copies of a plea agreement and an advice of rights for the court.
Okay. Ms. McClure, is that a complete and accurate statement of the plea agreement?
So there's 3 files. Is that correct, Judge?
Yes.
So I only see 2 acknowledged on the plea form. I don't know what's happening with the 3rd file. Sorry, this is Mr. Bandetto's case. So I see a plea to count 1 in 309, dismissal with restitution in 310, and then what about the 3rd file?
I believe everything else is dismissed except for the restitution provision only on the other file. The other file is dismissed in its entirety.
Okay.
So the plea agreement lists all 3 files at the top where it says file number in the heading.
Okay, that must be what he meant by dismiss all remaining counts. I just took that to mean in file 309, but there are no other counts in 309. But that's fine. That's what the agreement is.
All right, Ms. Sanchez, would you raise your hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do, Your Honor.
And you are Betty Nicole Sanchez?
Yes, Your Honor.
Ms. Sanchez, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1 in file 25-22309-FH, possession of fentanyl of less than 25 grams?
Yes.
You understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine.
Yes.
Is it also your intention to plead guilty today to the contempt charge for failing to appear on January 19th, 2023 in district court?
Yes.
Is it also your intention to plead guilty today to the contempt charge for failing to appear I can't determine what the other 2 of these alleged contempts are, so I'm just going to take a plea on one and dismiss the others. Do you understand that the maximum possible penalty for contempt of court is up to 93 days in jail or $7,500 in fines?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Ms. Sanchez?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
Yeah.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about July 6, 2022, in the city of Adrian, County of Lenawee, that you did commit the offense of possession of fentanyl of less than 25 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Sanchez to plead guilty?
None, Your Honor.
No, Your Honor.
Ms. Sanchez, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. You understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, you want to establish the factual basis?
Yes, thank you, Your Honor. Ms. Sanchez. I'm sorry, Your Honor. Give me just a second. Get my attention. Back on July 6, 2022, were you in the city of Adrian, county of Lenawee, state of Michigan? Yes. Were you near the Myers store? Yes. Thank you. And at that time, did you knowingly possess less than 25 grams of mixture containing the controlled substance fentanyl? Yes. And you know that, and you knew that was contrary to law? Yes. And you had no prescription for that? No. And also at that time, did you take some things from Meyer? Yes. And did those have a value of $516, I believe? One moment.
516 of the restitution for the other case. Then it wasn't worth 516.
The plea agreement says the restitution is.
That's for the other charge.
Oh,
yeah, that's not for the stuff from
okay.
Myers.
Okay. Well, on the date and time listed for that charge.
Yes.
Did the restitution, did you take property?
Yes.
And you took it from a store being open for business?
Well, yes.
Yeah. Okay. And the restitution value is $560?
Yes.
Thank you.
The people are satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D? Ms. McClure?
It has.
Ms. Underwood?
It has.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Sanchez has had full knowledge of her rights. She's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for September 11th at 8:15 a.m. Ms. Sanchez, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Excuse me, Judge. The next sentencing date would be September 18th. You're off on September 11th.
No, I'm sorry. So it'll be September 18th.
She pled to a felony.
Correct.
She's gonna need to go across the hall.
Okay.
Hey, Ms. Sanchez, I'm going to meet you in the hallway so we can set you up with those drug screens until you're sentencing, okay?
Okay.
Okay, and Ms. Sanchez, do you understand that all of the rights that I described to you, you would have with respect to the contempt of court charge as well?
Yes.
And how do you want to plead to the contempt of court for failing to appear on January 19th, 2023 at the probable cause conference?
Guilty.
All right, I will accept that plea as well. We'll set the sentencing for the same day.
Thank you.
Let's see, we also need fingerprints for this case, Ms. Sanchez. Give me a moment. I will print a copy of the order for prints, and you will need to take that to the Adrian Police Department and have your fingerprints taken. Can you print the order for prints at this print?
You change your print.
Okay, the bailiff's going to hand you a copy of the order for prints. You'll need to take that to the Adrian Police Department Monday through Thursday at 7:30 a.m. is when they do the fingerprint.
At 7:30 a.m.?
Yeah.
Okay.
And you will need to step across the hall to the probation department. They will have some information to give you about your pre-sentence investigation. Anything else we need to address today, Ms. or Ms. Underwood?
No, thank you.
Okay, we're all set.
Your Honor, the Zoom with Randy Torres never connected.
Oh, I'm sorry. Let me set that up again.
Rhonda, are we ready to do the bench warrant on McClenny?
That's fine.
I'm sorry, Mr. Murphy, I was having an issue with one of the other breakout rooms, so give me a second and I will get that set up again.
Thank you, Your Honor.
All right, Mr. Torres, there should be something on your screen asking you to join a breakout session. Go ahead and click join. I think, Ms. Underwood, that Ms. McClenny Dallas is here by Zoom.
That didn't work again, Your Honor.
Yeah, Mr. Torres, can you hear me?
Yes, sir. If I hit the button, but it don't do nothing.
Okay, can you call the jail until getting to the breakout session? All right, 1 second, Mr. Glazier will.
All right.
He just figured it out, so give me a second.
All right.
think it's okay now.
You think he's in there now?
Yeah.
Okay, he's in there now, so I think we're good. All right, thank you.
Okay, Miss York Bianca, your name is Brooks now. Was it formerly McClenny Vidales? Your device is muted. I'm going to send you a request to unmute. Ms. Brooks, I need you to unmute your device. So tap your screen. You should see a microphone with a red slash through it, and then tap on that to unmute.
Can you hear me now?
Yes, I can.
Okay. Yeah, I was formerly McClenny Vidales, but I'm actually clerk now.
Okay. Ms. Underwood, are you need to speak to her?
I don't believe so, Your Honor.
All right, this is file 25-22160-FH, People versus Bianca McClenny Vidales. We are here today for a pretrial conference. In this case, we are proceeding by video conference and in person. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brenner?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Ron Underwood for Ms. Brooks this morning, Your Honor.
All right, and where do we stand with this case today, Ms. Underwood?
Ms. Brooks, we don't have any record of that payment from June that you sent. Okay, so you're going to have to track that down. Have you made any payments since?
Yeah, after I spoke with you, we tried to track it down, so I just went and handled it that day by debit card over the online. So we're still working on getting that one tracked down, but I went on and paid it anyway.
And how much did you pay?
The $250.
Okay. Your Honor, on that basis, I would ask, and I hope the Attorney General would agree to a 60-day adjournment where Ms. Vidales can get these payments done through her debit from her new account, and we can see them more clearly and keep track of them.
Your Honor, since there hasn't been a payment since May, I would agree to a 30-day adjournment so that I can see that that actually processes through and that what she's telling the court is accurate.
Okay, so what I'll do is adjourn this to September 3rd at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Just to adjourn with Ms. Brenner's permission.
Yes, thank you.
Okay, so you will need to log in on September 3rd at 8:15. You'll use all the same login information that you used today.
Okay.
So you're all set for today. You can go ahead and log out.
Thank you, Judge. Rhonda, I'll see you over in Judge Ansel.
Thank you, Ms. Brenner. Rhonda, did you have a pickup?
Oh, I do. Do you want to call? Or do you have the warrant? I never got the warrant, so. I don't have the warrant on that, so I can't do that yet. I do have Mr. Rodriguez, though.
I believe I'm free to go.
I have Rodolfo Rodriguez.
I don't have a Rodolfo Rodriguez.
Oh, you know what? That was a probation violation summons, so you won't need to be here for that. Here. Okay. You're all set, Ron. Thank you.
Thank you.
This is file 21-20651-FH, People versus Rodolfo Rodriguez. We are here today for a hearing on requesting summons for probation violation. We are proceeding in person. The courtroom also has a Zoom session running. The record should reflect that this matter was set for hearing on a request and summons for probation violation this morning at 8:15 a.m. It is now 9:56 a.m. Mr. Rodriguez has not appeared either by coming to the courtroom in person or by logging into the Zoom session. I am going to issue a bench warrant for the failure to appear. I will set bond on that bench warrant in the amount of $1,203.
Thank you, Judge.
Judge, I was on the phone with Mr. Glazier. Did you need me at all, or did you call a case? I'm sorry.
No, I have not called any. Well,
Okay.
yeah, no, I haven't called anything that you were needed for.
Okay, thanks.
Okay, Mr. Murphy, are you ready to proceed with Ms. Coley's case?
Yes, Your Honor.
This is file 25-22120-FH People versus Cassie Lynn Coley. We are here today for a pretrial hearing as well as a hearings on contempt of court charges in that file. We are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, behalf of the people.
Matthew Murphy, appearing on behalf of Ms. Coley.
And Mr. Murphy, where do we stand with Ms. Coley's case today?
Your Honor, from my understanding, the offer from the prosecution is still as it was previously in the matter, which is for Ms. Coley to plead as charged on both counts with no habitual offender status added onto those. Ms. Coley has indicated she doesn't want to take that offer. I'm asking the court to consider, well, I do understand the case has been pending for a bit of time, but I've been trying to get some communication. Unfortunately, Ms. Coley has obviously failed to appear and been out of communication with myself for a bit. And again, I was trying to get an understanding from Mr. Sneed if he was intending to add any charge for absconding or for issue with the electronic monitoring device. So I didn't want to set a trial right now. However, I do understand the case has been pending for a while, but I was asking the court just to consider allowing us to do one more pretrial just for a chance for Mr. Sneed to come back from vacation and for me to have a conversation with them about their intention. However, if the court was intending, did want to set a trial, I think a jury trial would only take one day. But again, I was asking just for one more pretrial and then possibly to ask the court to consider releasing Ms. Coley to an inpatient facility while on bond. If we could address that after the court sets the pretrial date.
I'll set it for a pretrial on August 13th at 8:15.
My office do a stipulation order for August 13th at 8:15, Your Honor. And if I may, Your Honor, may further, I wanted to argue just briefly more about allowing the court or the court allowing Ms. Coley's release to an inpatient. Obviously, as the court can see in the record, she has missed court dates, and the underlying charge you can see it's a retail fraud and an R&O. I believe Ms. Coley's criminal behavior as well as her failure to appear stem from an addiction issue that she's trying to deal with, that she's been dealing with for some time. And as such, we'd ask the court to consider releasing her to an inpatient facility. Obviously, the court knows that we can facilitate that along with the help of Mr. Coast or help assist Mr. Coast in trying to facilitate that. I think that might be beneficial for Ms. Coley in addressing the underlying issues that have stemming this criminal behavior. So we'd ask the court to consider that at this time. Again, we do understand there is obviously issues with failure to appear, but we believe that's stemming from the substance abuse issue.
Ms. McClure, anything that people would like to say with respect to that?
Yes, Your Honor. As it relates to the bond request, I would just indicate that Miss Coley had absconded for almost 2 years on these charges. And then when given a chance on tether, she did cut off the tether. I don't think she's given us any indication that if placed in an inpatient facility that she would remain there. I think it's likely she would leave in violation of court's orders, just given her her history of failing to appear and absconding. As it relates to the pending case and putting it out for pretrial, I'll indicate that the offer from Mr. Sneed at this time is to plead to an attempt retail fraud first and an RNO, and then also plead to her retail fraud second, with restitution on both files. There has been no request from law enforcement for her to be charged with absconding or with removing the tether. But certainly Mr. Sneed can speak with Mr. Murphy about that if he's intending to seek that. But law enforcement has not submitted for that.
Thank you for that update, Ms. McClure. Thank you.
Okay, it looks like Ms. Coley had 3 failures to appear where bench warrants were issued while this case was pending in district court. In addition to that, she's had 2 failures to appear while the case was pending in circuit court and a bench warrant for cutting off the tether. I don't think under those circumstances I can modify bond to allow for a release. There just isn't a history here that would suggest that if she was released, she's likely to appear for her court hearings. So I think the situation needs to remain the same until we have this resolved. And once resolved, it does appear that probably treatment is appropriate, but I just don't have any confidence that that's going to happen. That she's going to appear if I release her now before we have this settled. So I would deny the request.
Thank you for considering it, Your Honor.
Ms. Coley, you can let the officer with you know that you are done with work for today.
Thank you, Your Honor.
Ms. Coley, I'll Zoom with you, if not this afternoon, tomorrow, okay?
All right, thank you. Have a good day.
Thank you, Your Honor.
Oh,
Thank you.
okay, Mr. Murphy, do you need to speak to Mr. West?
I don't think so, Your Honor. We can proceed on the record.
Okay, let me do Mr. Torres's case first, then we'll do Mr. West next. This is file 25-22298-FH and 25-22299-FH, People versus Randy Torres. We are here today for pretrial conferences. In both of those cases, we're proceeding by video conference. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, may have the people.
Mr. Glazer, if you said something, you were muted.
John Glazer on behalf of Mr. Torres.
And where are we with Mr. Torres's cases today, Mr. Glazer?
Your Honor, we'd asked to adjourn it just a couple of weeks. And talking with with Phoebe, she indicated there may be another file, and we want to check and see if that actually exists or if it's some sort of error. She thinks there is another UDA, and if there is, we would like to try to resolve all 3 of those at once. But we got to first see if it even exists.
And just for the record, I do think it's an error. I think it's a duplicate charge that was submitted for the UDA that's in front of this court, but it does appear to be pending in district court, and I think that needs to be removed from district court. I think, like I said, it's showing as the same date of offense, the same police report. It just has a different court file number, but it otherwise appears to be a duplicate charge or in a duplicate file.
What are you looking at that shows that?
My court.
Okay. All right. I'll check and see if there's anything down there. I'm not, he isn't aware of anything, but
Yeah, no, like I said, I believe it's an error. It needs to be taken out of the system because I believe it's a duplicate.
all right.
So I can adjourn this to August 27th at 8:15. Mr. Glazer, could you do the stipulation in order for adjournment?
Yes, Your Honor.
Is there anything else that we need to address today?
No, Your Honor.
Nothing on behalf of the people.
Okay, Mr. Torres, you can let the officer with you know that you're done with court for today.
Yes, sir.
Just call for Mr. Wade. Okay, this is file 20-20069-FH in, I'm sorry, Wendell West. This is file 20-20069-FH and 25-22294-FH. People versus Wendell Charles West. We're here today for a pretrial in both cases. The 20 case also has contempt of courts for failure to appear in violation of bond conditions. We're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, map the people.
Matthew Murphy, appearing on behalf of Mr. West.
And Mr. Murphy, where are we with Mr. West's cases today?
Your Honor, at this time, my understanding from the communication from Mr. Bayonetto is that the offer on Mr. West on his two files would be for him to plead as charged, the OWI thirds, with no objection to him entering into sobriety court. At this time, I was trying to get further understanding if we could try to figure out an agreement for no jail in the matter from the prosecution. I was going to ask the court, well, I understand one of the files is fairly old. The other file is not as old, and obviously we came on, I came onto the cases when the new file was charged. So I'd ask the court to consider just one more pretrial. Give me a chance to talk to Mr. Bayonetto further about the situation and see if we can get something worked out by that pretrial. And if not, I think we'd end up setting trial in the matter possibly at that point.
Okay, Ms. McClure, is there anything we need to address on the people's side?
No, nothing on behalf of the people.
I'll set this then for September 3rd at 8:15.
Thank you, Your Honor. My office do a stipulation order for September 3rd at 8:15 for both files.
Okay, so Mr. West, your next date is September 3rd at 8:15. You'll log in using all the same Zoom information that you used to log in today.
Yes, sir. Thank you.
And Mr. Murphy, do you need to speak to Ms. Taylor?
Only if she had questions. I think Mr. Malaro was anticipating just another adjournment or trial being set.
Okay, Ms. Taylor. sorry, whose decision?
Person?
Yeah. They're here.
Judge, I don't know if you actually need to call the case for Miss Taylor or not. I have down that Mr. Bayonetto well, I have down that he filed a dismissal yesterday, but if that's not been received by the court, I'll have him follow up on that.
Oh, okay. Well, let me look. Okay, I don't see it in the computer system yet, but I'll look for that up here. If it's been filed, we'll get that taken care of. Sure why this was on docket today, because it's kind of truck. They both represented by attorneys in the room. Okay, Cadell. This is file 19, I'm sorry, file 20-19914-FH, People versus Matthew Allen Cadell. We are here today for a hearing on a request and summons for probation violation. We are proceeding today in person. The courtroom is also open to the public. The record should reflect this matter was set for a probation violation summons on, or I'm sorry, set for today at 8:15 a.m. It is now 10:14 a.m. Mr. Cadell has not appeared. The alleged probation violation is related to a guilty plea that Mr. Cadell entered for a use of cocaine charge back on July 2nd and is set for sentencing on August 8th.
Judge, is this Matthew Cadell?
It is.
Okay, and I just spoke to him this morning. He just had a positive swab for both cocaine and also THC. Let me give him a call real quick and see if he could log on.
Okay. Mr. Glazer, do you need to speak to Mr. White Eagle?
Yes, Your Honor. It says
Okay.
it's on Ann's loans. Okay, thanks. Bye.
Judge, I did speak with Mr. Cadell. He's going to log in right now.
Okay, thank you. Mr. Glazer, are you back from that breakout session or did you not
Yeah,
get there
yeah.
yet?
Yes, I am, Your Honor. Sorry about that.
I apologize. Yeah. This is file 23-21423-FH and 25-22235-FH. People versus John F. Kennedy White Eagle. We are here today for a probation violation in the 23 case and a pretrial in the 25 case. 25 case also has a pending contempt for alleged violation of bond conditions. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B. McClure, may I have the people?
John Glazier on behalf of the defendant, Your Honor.
And where are we with Mr. White Eagle's cases today, Mr. Glazier?
Your Honor, on the underlying file here, he's going to plead guilty to count 2, possession of cocaine and driving a motor vehicle without insurance, with the understanding that all the other charges in the habitual offender to be dismissed.
So that was 1 and 3?
1 or 2 and 3, I think.
2 and 3, I'm sorry.
Yeah, 2 and 3.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right. Could you call the jail and have them take him advice of rights? Do we have a signed advice of rights form, Mr. Glazier?
Not that I know of. He's been in jail.
All right. We're having the jail take one to him in that booth for review and signature.
There's also a plea form dated July 8th of this year. I don't know if he needs to sign that or not.
For him to sign. Thank you so much. Bye.
And I'm sorry, Mr. Glazier, did you say what he was going to do with the contempts?
Your Honor, what are the contempt of courts for testing positive, and what's the other contempt?
I think it's just that. It's just the one for a positive test.
It's kind of an odd situation, Your Honor. I know that it was for testing positive. We can set it for a hearing if you want. The situation is my client, he said he took a test and it had a faint line and they told him not to worry about it. He tried to talk to Miss Teskey about it and she was busy in a meeting and then it just got issued. But he says he hasn't used any. He's got a sheet showing he's going to all his AAs. He's got all the sign-ins for that. Is that AA or NA?
That's AA. NA.
AA. And we're trying to get him into a program, Your Honor. But he knows he's not going to win a contempt trial. But I guess he'd plead guilty with that explanation. He doesn't believe he was using any drugs.
Judge, I wanted to point out that he was taken into custody in your courtroom on July 2nd. You ordered for him to do a drug screen for me, offered him a test, and he refused to do it.
Yeah, Your Honor, I'd like to point out also, he came in and told me it was for him. Now, I had been one test where the cup was no good, and he did not inform me that it was you, Your Honor. And I apologize for that because I thought it was for him, and I have already had a faint line with the cup. Had I known it was for you, I was already upset, which I apologize for. That's why I refused it, not because I was dirty, because I was not dirty at all. I have been clean ever since I did the 30 days I got out. I knew what was at stake. I did everything I was supposed to be doing. I signed up for the outpatient. I was going to meetings, which I have paperwork right here every day for the 90 days. I reported to Miss Teskey that it was impossible that I was dirty. And the minister, he even told me that it was a thin line. Don't worry about it. But then a second one came dirty for a false positive for a Suboxone. I don't even know what a Suboxone is. Then I left a message with Miss Teskey. I got no reply back. I went down there in person because I was having problems paying for it. I went to look for Mr. Darren at the downstairs of probation and asked him, could he take the test for me for free because I was having problems borrowing money. They said no. That's when I went back and I borrowed money from my mom again, and I tested positive with a thin line for that Suboxone. So then Monday morning, I went in there and told Miss Teskey, I said, hey, I need to talk to you. She said, I can't right now. I'm in a meeting. I said, hey, I got 2 false positives, for one for cocaine and another one for a drug that I've never even seen. And she goes, well, I can't help you right now. I'm in a meeting. I said, it's not fair to me and my sobriety. And nobody would listen to me. So then I came again, when I came to court, somebody had issued a arrest warrant. I don't know if that information, Ms. Teskey had passed that along to anybody. I've been doing everything, Your Honor. I've been clean.
All right. What I will do is I'm just going to set that over. Obviously, if she's going to plead guilty, we're going to set a sentencing date for those. I'll just set that over until that date, and we'll figure out what to do with it at the sentencing hearing.
Okay.
Mr. White Eagle, would you raise your right hand?
Yes, sir.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir, I do.
And you are John F. Kennedy White Eagle?
Yes, sir.
Mr. White Eagle, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of cocaine of less than 25 grams?
Yes, sir, it is.
Is it also your intention to plead guilty today to count 3, operating a motor vehicle without security?
Yes, sir, it is.
You can put your hand down if you want. Do you understand that the maximum possible penalty for the possession of cocaine charge is up to 4 years in prison and or a $25,000 fine?
Yes, sir, I do.
Do you understand that the maximum possible penalty for the operating without security charge is up to 1 year in jail and or not less than a $200 nor more than a $500 fine?
Yes, sir, I understand.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes, sir, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Whitehall, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir, I do.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir, I do not.
Do you understand that you're giving those rights up?
Yes, sir, I understand.
How do you wish to plead to the charge that on or about April 10, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of possession of cocaine less than 25 grams?
I plead guilty.
And how do you wish to plead to the charge that on or about April 10, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of operating a motor vehicle without security?
Plead guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
I understand that.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. White Eagle to plead guilty?
No, Your Honor.
Mr. Glazier?
No, Your Honor.
Mr. White Eagle, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, just mentioned about maybe a program. I don't know.
I'm sorry, I couldn't hear you.
We just mentioned about trying to get into a program. That's about it. But other than
Okay. Do you understand, regardless of any discussions you may have had with Mr. Glazier about that, that ultimately it's the court's job to set the sentence?
yes, sir, I understand that.
If the plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating any terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I surely do. Yes, sir, I do.
Is it your own choice to plead guilty today?
Yes, sir, it is.
Mr. Glazier, do you want to cover the factual basis?
Yes, Your Honor. Mr. White Eagle, back on April 10th of this year, you came into contact with the police, is that correct?
Yes, that is correct.
And that was here in Lenawee County in the state of Michigan?
Yes, sir, it was.
And at that time, you had in your possession some cocaine, is that correct?
Yes.
All right, and you also were driving a car without any insurance, is that correct?
Yes, sir.
All right, I don't have any other questions, Your Honor.
All right.
Ms. McClure, any questions?
No, satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Glazier?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. White Eagle has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 4th at 8:15.
Is it Mr. Glazier?
Your Honor, I think you changed my client's bond. He wanted to address that if he could. He was out on bond and I think he was in court for that positive test was why he was in court last.
Okay, so what do you want to say about the bond then?
Well, we would ask if you'd consider doing a PR bond with testing. He'll do what, he's doing the testing, he's going to AA. But we'd ask, he's explained his version of why he tested positive. And we just asked the court to take that into consideration.
Ms. McClure, is there anything the people would like to say with respect to that issue?
Just that I don't know that it was just the positive drug test, but he did again miss testing and failed to test when requested on July 2nd. So I don't know that it's accurate to say that he's been testing.
I don't, the contempt of courts were for not testing that I know about.
Yeah, John, he had a contempt for 2 positive tests over at the center for both for
Right,
cocaine.
I don't think
And then he was
not-
ordered a test for me on July 2nd, and he
There is
declined.
no contempt for that.
That was, the court said they were gonna retest him, right? The only thing I can tell you, Your Honor, is he's been, this has been pending a while, and that's the only allegation of a false positive. There aren't any allegations that he missed any testing.
Well, in May he did test positive and was sentenced for 30 days.
Yeah, that's what we're here on now. That was handled on July 2nd, the judge.
That was a separate contempt.
Those are separate incidents, Mr. Glazer.
Yeah.
Well, I'm not aware of the one in May. I don't have anything in my notes about that.
Yeah, he tested positive on 6/23 and also 6/24 for the cocaine.
But prior to that, he's had
Correct.
other contempts while the case has been pending.
Correct.
I don't have any
I've
notes.
already did time for those contempts, so.
I don't have any notes to that effect in my file. I'm unaware if he did.
Because I've
Well, I'm
already
looking
done
at a
time.
judgment of contempt where he was sentenced to 30 days for contempt of court on May 21st.
Yes, sir.
Okay. Yeah, I must not have handled it because it's not in my file.
And I've been clean ever since.
All right, so what I will be willing to do is modify the bond so that he can enter an inpatient treatment facility.
Okay.
I'm not willing to do a straight PR bond at this time, given what's in front of me, but it appears that Mr. White Eagle is interested in doing treatment, and I'm willing to do that. So
Thank you,
I
sir.
will modify the bond so that he can be released to an inpatient treatment facility.
Yeah. The girl in my office says, make sure that that's in the order, that he can be released, and she'll try to get him in.
Yeah, that will be in his the new version of his pretrial release order.
Okay, thank you, Your Honor.
Thank you.
Is there a violation? A probation file?
There is, thank you. Okay, so Mr. Glazer, do you know what he wants to do with the violation of probations that he has in the 23 file? Those were for possession of methamphetamine, possession of cocaine, and driving while license suspended.
He'll plead to that based on the possession of cocaine, Your Honor.
All right, Mr. White Eagle, do you understand that with respect to the violation of probation in the 2023 case, you would have all the same rights that I've already described to you?
Yes, sir.
Do you understand that in that case, you had pled guilty to possession of methamphetamine, and the maximum possible penalty for that offense is up to 10 years in prison?
Yes, sir.
Again, you would have the right to have a trial, and everything that I described previously. The only difference would be at that trial, the proof would have to be by a preponderance of evidence rather than beyond a reasonable doubt. Do you understand that?
So yeah, we're talking about the violation of that case?
Correct. The violation of probation has a different standard of proof than in your other file where you were accused of a new crime. Do you understand that?
Yes, sir.
Okay. And do you understand that that would be a lower standard of proof than beyond a reasonable doubt?
Yes, sir. Yes, I understand that.
And so how do you want to plead today that you violated your probation in the 23-21423-FH case by being in possession of cocaine?
I plead guilty.
Do you understand that by pleading guilty to that violation of probation, you're giving up all those rights that we talked about earlier?
Yes, sir, I do.
Has anything been promised to get you to plead guilty to this violation of probation?
No, sir.
Have you been threatened in any way in order to get you to plead guilty to the violation of probation?
No, sir.
If I accept the pleas, you're giving up any claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
So in that 2023 case, you had been on probation since about September or October of 2023. Is that right?
Yes, sir.
And one of the conditions of your probation was that you not use or possess any controlled substances. Is that correct?
Yes, sir, that is correct.
And in fact, you just pled guilty to possession of cocaine from an incident that occurred on April 10, 2025. Is that correct?
Yes, sir.
Okay, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. White Eagle has had full knowledge of his rights to competent counsel. I'll refer this to the probation department also and set the sentencing for the same date that we've already established.
Your Honor, I would ask that that file reflect if he could be released to an inpatient program as well. I know Emily White's going to try to get him into it as soon as this is done.
We'll issue a pretrial release order in that file that has the same condition that he can be released to a residential inpatient treatment facility.
Thank you, Your Honor.
All right. Thank you, Your Honor.
Thank you, Mr. Glazier.
Okay, we're all set then. Mr. White Eagle, you can let the officer that's with you know that you are done with court for today.
And I hand him this statement of rights thing also?
Yeah, have you had a chance to read that?
Not yet. I will read it and sign it though.
Okay, yeah, go ahead and read that, sign it, and just give it back to the officer at the jail, and they'll send it over here to the courthouse.
Yes, sir. Thank you.
Okay, you're all set for today then. Thank you.
All right. Thank you, Mr. Glazier.
Yep. I think that's all I have with you this morning. Thank you, Your Honor.
Okay, thank you, Mr. Glazier.
I have no idea what you're talking about.
She just told me that she hoped that like woke up out of my sleep.
Okay, I have someone logged in with a screen name of Motorola Moto G Play 2023. Can you turn your video on and unmute your device, please?
Yes, sir.
Okay. All right, this is file 20-19914-FH. People versus Matthew Allen Cadell. We are here today for an arraignment on a request and summons for probation violation. Sir, you are Matthew Allen Cadell?
Yes, sir.
All right, Mr. Cadell, have you received a copy of the request and summons for probation violation?
No, I didn't. I ain't even know I had court today for this. I thought all this was wrapped up in my plea agreement.
Okay.
I sent you a copy to your address.
Yes, but in court, man, Murphy, we discussed all this supposed to be. This supposed to be excluded with my plea agreement.
Well, it couldn't be included in your plea agreement because it wasn't charged until after you pled. So this is an alleged probation violation on an older file.
Okay.
Give me just a moment here.